Good morning. Hi, my name is attorney Romy Jurado. I'm an attorney here in Florida. I've been doing this for over 12 years now. I practice mainly in the areas of business law, business immigration, and we deal, of course, with litigation. So today's presentation is about how to represent the buyer of a business. I'm looking at it from a transactional perspective, but I'm also going to try to answer any and all of your litigation-related questions, because as we know, deals can go sour. Our law firm is located in Miami, but we do help clients all over the state of Florida. We're able to help clients in different areas of law, such as immigration, litigation, probate, estate planning, see what I'm missing, trademarks, copyrights, business law, and of course, the buying of a business. So I want to first thank you all for being here with me today. I know that it's the holiday time and everybody's so busy. So thank you for taking the time and joining me. I hope I can answer all your questions. I will send everybody a follow-up email with the presentation, and this is being recorded. And if it comes out good, then I'll send everybody a copy of the recording as well. Please feel free to put all your questions in the chat or in the Q&A, and I will try to answer them all today. Let me start with sharing my screen. Give me just 1 second. Okay, perfect. Everybody should be able to see my screen now, and everybody should be able to hear me. Thank you again for being with me. So let's get started. So how to successfully represent the buyer of a business. Now, I know a lot of you guys are realtors and you're used to selling a house, right? So when you sell a house, you have pretty much templates that you can use. So you just kind of just fill in the blank. When it comes to selling a business or helping somebody sell a business, there's really no templates. There's nowhere where I can send you and be like, here's all the templates that you need. So all the time we prepare those contracts. We prepare listing agreements. We prepare the purchase agreements. We prepare the letter of intent. We prepare all of that. Here's a little outline, as you can see in your screen, of how we go about it. The first document, of course, is an NDA, a non-disclosure agreement. And I'll explain to you guys why that is so important and why you cannot show any businesses unless you have this. It would also talk about how to use the purchase of a business, how it can lead to an immigration visa, sometimes residency as well. The importance of a letter of intent, right? Basically, a letter of intent is an agreement to agree. I want you guys to understand what an asset purchase agreement is. And, there's also a stock purchase. There's also membership interest transfer agreements. And that's when you buy the whole company. And I will talk a little bit about that too. Also, what happens through due diligence period, that is a very important period where we get involved a lot in analyzing the business itself. The essential steps to closing, I want you to understand how it happens, a little timeline. And then, of course, the use of non-compete and non-solicitation agreements when buying a business. So that's a little outline for today's class. Again, any questions, please feel free to put them in the chat and I can see them right here and answer. So a non-disclosure agreement. An NDA, right, or otherwise known as a confidential agreement, is a legal contract in which a party promises to protect the confidentiality of a secret that is disclosed to him or her for a certain amount of time. Why is this important? Well, let's pretend that I own a hair salon and I want to sell my hair salon. Well, if you bring me a buyer, right, you don't know who that buyer is. It might be somebody that's planning to put a hair salon right in front of mine. It might be somebody that has already a hair salon and all they want to do is come in, learn my information, my financials, who my vendors are, who my employees are, so that they can come and steal all of them for their own business. And that happens in any industry. You can be in the hair salon business, in the pharmacy business, and I've seen it happen even in the accounting business, any business, so people see you doing good and they may want to steal your information, such as your vendors, your clients, your financials, even your employees. So a confidentiality agreement prevents that from happening because it says whoever you bring over to see my business cannot use the information that they've learned from my business for their own benefit. They can only use it to pretty much buy my business. That is the whole point of it. They're coming, I'm teaching them, I'm telling them stuff about my business so they can buy my business, not so they can use that information against me. So that's why whenever I'm representing the seller and business brokers, realtors are bringing in buyers, I want to make sure that they have signed a non-disclosure agreement, right? I want them not to be able to use the information that I'm giving them. If I'm representing the buyer, then I want them to sign a mutual non-disclosure agreement. I want the sellers to agree that they're also not going to use the information of my buyer and whatever they provide to them for their own benefit. But that's if I'm representing the buyer, right? So the non-disclosure agreement can be unilateral, meaning it only protects one party, or it could be mutual because it could protect both parties' information. It just depends the transaction, what your negotiating power is, and how you get the seller or the buyer to sign. So again, a non-disclosure agreement is extremely needed. It is so important when you're representing the seller. You want to be able to bring all your buyers in, but you don't want them to steal information, right? Plus, the seller is not going to want to show their financials, show their list of customers, show their list of vendors, unless they know that that information is protected. So, and that's what the NDA essentially does, a non-disclosure agreement. It ensures that any buyer who's giving access to the financial or any proprietary information disclosed by the seller will not disclose that information to any other party who hasn't also signed the NDA, okay? So if your buyer is asking you, why do I need to sign an NDA? Because otherwise the sellers will not give you information, and it is extremely important. It goes also not just when you're selling a business, okay? This applies whenever you have a business idea that you're looking for investors, whenever you want to show any information to anybody, something that you want to protect, make them sign a non-disclosure agreement. Because if you don't, then they can use that information you're providing to them and do whatever they want with it. And I do see a lot of this in the litigation side of our practice, because they come to me and they're like, Rumi, I sat in front of this investor. I told him this great idea that I had. He seemed so interested. We were going to go to the next steps. And then I see that he went and stole my idea. What can I do? Nothing. If you didn't make them sign an NDA, a non-disclosure agreement. You just gave them your idea, and now they can go and do whatever they want with it. So that is why it's so important, not just when you're selling a business, but also when you are explaining, showing any type of idea. So what are the essential parts of a non-disclosure agreement? We want to talk about the location, the name, the type of business, right? The length of time. So how long can you not use this information? 1 year, 2 years, 3 years? You know, we want to put how long it's going to last, the validity period. Also, who are those parties to the agreement, right? If I'm representing the seller, I want to bind the buyer. I want to bind any buyer's affiliates, their family members, because maybe they don't do it, but maybe they, give the information to somebody else who then uses the information to steal the idea. So I want to be as broad as possible if I'm representing the seller. If I'm representing the buyer, then of course I want to limit that. I want to limit the the non-disclosure just to the named buyer, nobody else. And of course, you have to say what information cannot be disclosed. Is it the financial records? Is it the contracts with the staff, the suppliers, the vendors? What information is it that we are protecting? So that was the NDA. Now let's talk about visas opportunities, right? So if you're representing anybody buying a business, they could potentially apply for a visa. For example, if they have a business abroad, they have any type of business. Let's say abroad, they have a factory. And in the United States, they plan to buy a hair salon. We can potentially apply for a visa called the L1 visa. The L1 visa allows a foreigner, okay, to open up a subsidiary of their business abroad and be able to send either themselves or an employee to come to the United States to work here, to live here, and eventually obtain residency. The business abroad does not have to be the same business here. So you can have two different businesses. So abroad, you can have a factory, and here you can have a hair salon. I've done it where abroad, they had a law firm, and then here they open up a little daycare. So it doesn't matter. It doesn't have to be the same type of business. What matters is that we establish something called a corporate relationship, a business relationship. So what type of relationship? Well, it has to be a qualifying one. So either the foreign company owns 100% of the US company, the foreign company is a subsidiary of the US company, the foreign company is an affiliate or a branch. And that's something that we establish when we form the US entity. So what will happen is we will form the US entity, then the US entity will acquire the business. And because of that, we are able to either send the owner or send an executive, a manager of the foreign company to come to the United States to work here and eventually to apply for residency and eventual citizenship. They allow this because they want to be able to have what they call intercompany transferees. A lot of the big companies, they do this a lot. They send a lot of employees this way with an L1 visa because now you don't need to do something called a labor certification. So you don't need to show that you cannot find somebody to do the job like you would with a regular employment petition. Here, all you need to show is we have a company abroad. The company has a qualifying relationship with the United States. We have employees abroad, half of them professional. We have employees here, I would say at least 6 or 7. And we want to send this person from abroad to come and live here, work here, and eventually become a resident. Who can you send? You can send an executive, a manager, or somebody with specialized knowledge. An executive is somebody that has, that supervises other professionals. A manager is somebody that manages a particular function. That can be the marketing function, the sales function, the financial function. And somebody with specialized knowledge is somebody that has specialized knowledge about your business abroad that you need to send them here because they need to use the same knowledge to help your business here. Usually people are going to get the L1 visa for 1 year, okay? And then they can renew for an additional 2 years, and they can keep on renewing for a maximum of 7 years. The great thing is that after the first year, you are able to apply for residency. So that's actually great. The investment amount, I would tell you, I have done it with as little as 100,000, even less sometimes. What matters is how much the business costs in the United States, that is an actual business, right? With a location, that has the licenses, the permits. Any business will qualify as long as it's a legal business that has a location, licenses, permits, and that it has employees. If you have that and there's a company abroad, and this person that you're trying to send work for the company abroad for 1 year out of the past 3 years, then you're able to send them to the United States to work here and eventually obtain residency and citizenship. So it's really a great visa. There is no requirement of being from a specific country. You can be from any country and qualify for this visa. So this is a great thing. Next, we have the E2 visa. The E2 visa is a treaty visa. This one, you don't need a company abroad. You can come to the United States, buy any business you want, and apply to get a visa of 4 years, 5 years, which you can renew indefinitely as long as the business is going forward. For this visa, any business would do. I recommend at least 2 employees. It doesn't have to be a physical premises. It could be a consulting business with a virtual office, no problem. The minimum investment amount, I usually recommend 100,000. I have done it with less. It just depends on the type of business. Any business would do. We have done hair salons, clothing stores, grooming places for doggies and cats, shopping centers, real estate. We've done a lot of real estate for E2 visas. I have clients that come buy maybe 6 or 7 properties. They manage them through Airbnb. That works. I have clients that come and they buy a piece of land and they develop it, and their business is construction. No problem, that can qualify. Here we do have a restriction on the countries. And when I send you the follow-up email, I will include a link to all the countries, and I need to update it because I have great news from people from Portugal. If you're from Portugal, now you're going to be able to also qualify for an E2 visa. A lot of the European countries have treaties with the United States that make them allow, that is why they're allowed to get E2 visas. Not all of the South American countries have treaties with the United States, but for example, Colombia, Argentina, they do. Chile does. From Central American countries, we have Honduras, Mexico, Costa Rica, Panama. And for example, Brazil doesn't have a treaty with the United States, but a lot of Brazilians have citizenship from Italy, from Spain, and then we're able to do E2 visas for them. Or now maybe they have citizenships from Portugal and we're able to do E2 visas from them. Venezuelans don't have an E2 treaty with the United States. However, we've done a lot of E2 visas for Venezuelans. Why? Because they have Spanish citizenship, they have Italian citizenship, and now Portugal is one of the new countries and they have citizenship from there too. So it doesn't matter that you never lived in the country. It doesn't matter that you never even visited the country. What matters is that you have a passport from a treaty country, and then we're able to apply for an E2 visa. The E2 visa is really a great visa because the investment amount can be extremely low. I have even done 60,000. What matters is how much the business costs. The investor, the one that comes in, should own at least 50%. I like to have them own at least 51%. I would say that's the minimum that I like. Or they have to be in control of the business. It could be any business. We don't care as long as it's a legal business. At minimum of 2 employees. They don't have to be professionals, could be any employees, and then we could apply for an E2 visa. You will get the E2 visa depending on the country that you're from. For example, in Argentina, you get it for 5 years. In Honduras, you get it for 5.2. In Mexico, you get it for 4. In Chile, you get it for 1, but every time you come in, you get a stay of 2 years. So it just depends the country that you're from. Panama, Costa Rica, 5 years. And you can keep on renewing. There's no limits on the E2 visa. You can renew for one time, another 5 years, 5 times. As long as the business is going forward, you would be able to keep on renewing, okay? Lastly, we have the EB-5 visa. The EB-5 visa, it's also a fabulous visa. It's straight shot into residency. You are able to apply for an EB-5 visa if you buy an existing business and you save 10 jobs or create 10 new jobs, or you start a business from scratch. Any business would do, okay? Any business would do as long as you create the number of jobs or you save the number of jobs. What's important here, and this visa was designed for that, is to basically receive foreign money and help the US economy. So the job creation requirement is a must. It's 10 full-time jobs, people working 35 hours or more per week, and obviously paying them at least minimum salary, whatever, depending on the state that you're from, the minimum salary established by that. Now, there's 2 ways to do an investment EB-5 visa. One way is you take care of creating the job, buying the business or starting the business, or you do it through a regional center. Regional centers are private entities that had received a designation from immigration to receive foreign money and basically give it to projects. Maybe they're building a building, they're building a bridge. So they receive the foreign money and they give it to projects to use it. If your client does it through a regional center, so it's pretty much like they're giving them a loan at very little interest, but they'll be able to obtain the residency and citizenship eventually. Or they can decide to start a business on their own, right? And then the investment amount, it's going to be $1.5 million if they do it anywhere. Or if they find an area which has high unemployment or is a rural area, the investment amount, it's lower to $800,000. Any business would do. But the important amount is the investment amount and the number of employees. So anywhere, $1.5 million is the investment amount and 10 employees. Or if it's a rural area, and what is a rural area? It's any area outside of a metropolitan statistical area or outside the boundary of any city or town having a population of 20,000 or more, right? Then they're able to invest $800,000. If it's a city, it's not a rural area, okay? But maybe we can find an area with low unemployment. That's a possibility. So why is EB-5 so great? Because you're going to be able to get residency right off the bat. You get something called conditional residency for 2 years, and then we're able to remove the conditions if we show that we created the number of jobs. To apply for an EB-5 visa, we don't need to have the jobs from the get-go. What we need to do is to have the investment done. If we have the investment done, then we're able to apply for the visa. We don't need the jobs. The jobs can be created later, and then we remove the conditions, and then they're residents, and then they're citizens, and everybody's happy. For immigration purposes, before I go talk about the letter of intent, a family for immigration purposes is always going to be husband, wife, and children under 21 that are not married, okay? That's going to be a family for immigration purposes. We can include all the family, even if they have 10 kids, right? As long as they're legally married, the husband and the wife, they're going to be able to be included, and then any other kids that they have, no problem. If they have kids from other marriages, we're going to be able to include them too, as long as we show the relationship, the birth certificate and all of that. All right, so that's for immigration. If you have any questions, again, please put them in the chat or in the Q&A. Now let's talk about the letter of intent. That's basically the first step in buying and helping somebody buy a business, right? So the letter of intent acts like as a blueprint for the drafting of the final transaction documents. It helps both parties reach to an agreement on the material terms, the most important terms, early in the process. And it helps ensure that all the remaining issues are able to be worked out. So I like to draft the letter of intent. I understand that realtors sometimes they do it, but I like to do it myself because that way we can really hash down, these are the basic bullet points. This is what we really need. We negotiate that, and then later we go into drafting the transaction documents. In the letter of intent, what I like to include are, for example, what are we buying, right? So there's 2 ways to buy a business. One is you buy the whole company, or you buy the assets of the business, substantially all of the assets. And I like to enumerate them. What are we really buying? what law is it going to govern our transaction? Is it Florida law? What are conditions that need to be completed prior to closing, right? One of them should be, of course, the lease transfer, because while you're buying the business, you're not buying the lease. What liabilities we don't want, right? So probably there's going to be an SBA loan. A lot of people had businesses and obtained SBA loans during the time of the pandemic. And what they don't understand is that that SBA loan encumbers all of the assets. So that SBA loan needs to be paid out at closing or prior to closing for me to be able to transfer the business. So I want to talk about that in the letter of intent. The purchase price is so important, right? Does it include the inventory? Is there going to be an adjustment? Of course, confidentiality. We don't want them to use a letter of intent, show it to everybody, and then not be able to buy the business. Expenses, who's going to be paying for what? All of these things I like to put in the letter of intent that I draft for my buyers. And then we proceed to the deal documents, right? One of the most important documents, because most of the transactions, I will tell you, it's going to be an asset purchase agreement, where the buyer basically, buys all of the tangible and the intangible assets and liabilities of a seller. And it could be for cash, it could be finance. That's all going to be placed in the asset purchase agreement. And again, that's something that we draft. So what is it that we are going to put in the asset purchase agreement? We're going to say, for example, what are the acquired assets? What are the assumed liabilities, right? I want to specifically enumerate them. Also, I'm going to put in there what documents are we preparing for closing, such as the bill of sale for personal property. What intellectual property assignments do we need? Does the business own a trademark, right? Does it have a DBA that we need to transfer? I want to put for the assignment and assumption of agreements. Does the business have contracts with insurance companies? Does it have contracts with vendors? Does it have contracts with clients? And all of that needs to be transferred. And of course, we're going to say that we need to have the assignment of the lease prior to any closing. Another very important part of the asset purchase agreement is the representations and warranties. Obviously, we want to make sure that they include that the seller includes special representation that the assets are being acquired, and being able to use for the specific business that we're buying it for, that there's not going to be any liabilities or any outstanding issues with the assets. The thing is that while it's similar to buying a house, it's not really, because when you buy a business, you're not getting title insurance, right? So once you bought it, it's yours. And if you don't do good due diligence, good legal due diligence, which is one of the things that we do, and you don't do good financial due diligence, the seller could lie. So we want to put in there representations and warranties so that even if you did your due diligence and something didn't come up, you're able to come after the seller after closing, right? In order to be able to either get some money or get some type of fixing. If I'm representing the seller, I want to make those representations extremely narrow. And I want to say, and disclaim a bunch of things that I can. If I'm representing the buyer, I want to make those representations extremely broad. I want the seller to protect against everything and anything. So it all depends on who we're representing, how we draft those deal documents. Here, what you see on your screen now is just a little, kind of how we break down the asset purchase agreement. But again, it really depends to the particular transaction. We want to talk about definitions, closing conditions, covenants, what are they agreeing to, representations and warranties, termination, indemnification. That is so important for the seller to indemnify the buyer, right, for anything and everything that happened prior to closing. Because there are many things that we're not going to know. Like if you're buying a restaurant, let's say, and now you close, you own the restaurant. Well, what if they had an issue with an employee that no longer is working there, so you didn't know about it, and it happened a year or 2 years ago? Well, the employee may want to come after the restaurant, even though you only bought the assets, because you're operating the same location under the same name and in the same conditions. Now, we want the seller to be able to protect against that and basically indemnify you, pay for your attorney's fees, pay for your costs if that happens. Maybe a vendor, right, was owed money and they didn't sue the seller when they were owning it, but now they're going to sue you. Again, we want the seller to indemnify for all of this. If I'm representing the seller, I want to be like, listen, you're buying it, you're taking it as is. I want to be done with this. My seller is moving to Costa Rica, wants nothing to do with the business. So we want to make those warranties extremely narrow. So again, it always depends who are we representing. Now we're going to talk about due diligence and why it's so important. Well, the due diligence is the period immediately after the execution of the asset purchase agreement, and it allows the buyer or the buyer's attorney to conduct their independent legal research and investigate the validity of the business. Who are the owners? Guys have no idea, and girls, how many times we have a litigation where the seller of the business was not really the seller, but nobody did due diligence. Nobody verified that the seller actually owned the business. So the buyer went, gave some money, bought it, and now somebody else is saying, you didn't buy that business. I was the seller. So it is so important to do legal due diligence, and it is something that we do. Financial due diligence, it is extremely important too. That's something that the buyers, they do with their CPA, with their accountant. Sometimes they do it on their own. So it just depends. This time period, if I'm representing the buyer, I want to make it as broad as possible. If I can make it from, the day we sign the asset purchase agreement until the day we close, even better. Because then my buyer could always back out if something shows that we didn't like. If I'm representing the seller, I want to make that period extremely small. I want them to do their due diligence, and then they have 10 days. And if they didn't find anything, they have to close, or they lose their deposit. So it really does depend. So it depends on, the duration is so important. It depends on how the contract is written. When it's executed, you can do 10 days, you can do 90 days. It's whatever is negotiable. So what do I do during the due diligence, right? So I conduct legal research on all the parties associated with the transaction, not just the company, but the people too, the people that own it. So for example, I search the Florida Secure Transaction Registry, or UCC for short, to see if there's any debt that has been recorded against the business. A lot of times I find SBA loans, I find bank loans, I find loans. This happens a lot, especially in gyms, okay? So the buyer comes in, oh, excited, I'm buying this gym. I'm so excited, I'm gonna buy it. I'm gonna pay $200,000, great. We start the due diligence process, and I see that all of the machines, all of them have been, they were purchased through a loan, and they're all securing the loan. So now the seller is like, no, I never intended for me to sell the machines. I'm just selling him the location. And now the buyer's freaking out because they thought they were buying all of the machines and everything that's in it, and that's why they were getting such a good deal. Had we not done due diligence, I could promise you that closing would have gone through. And then at the end, the seller would have realized, the buyer would have realized that they needed to keep paying this money monthly. Otherwise, all of the machines would be gone, and it would have been a horrible, horrible show. So due diligence is so important. We check the UCC to see if there's any recorded debt against the business or against the people that own the business, because there could be a debt recording against a seller in their own personal name that encumbers the assets of the business. We also check the Florida Department of State. We do the Division of Corporations, because if there's a judgment, it should be recorded there, right? So we want to know if there's any judgment against the people or the company itself, because there's a judgment, guess what? That business cannot be sold, or it could be sold, but the judgment needs to be satisfied. We also check the clerks of courts records, right? Civil litigation. We check if there's any active lawsuit in the county where the company is at. Why? Because if there is, now there's a statute in Florida, it's called fraudulent transfer statute, that you cannot sell your assets, sell your stuff if you're anticipating litigation or if you are in litigation. So if there's any active case, we want to know about it. Of course, we can still sell, we can do indemnifications, we can then tailor the transaction to be able to proceed, even though we have an active litigation, if the buyer wants to buy it. Sometimes I even negotiate with the people that are suing the business, and I say, listen, we have an active litigation, I have a buyer that wants to buy this business, what can we work out? And sometimes we work it out and we're still able to buy the business. The important thing is that we know about it, right? No surprises. We also check the business tax status, both of the county and the city. We check the county tangible tax status, and we do a comprehensive asset search to see if there's anything else that we couldn't search for that might pop up. This is the legal due diligence that we do. If it's a restaurant or anybody that collects sales tax, then we do a sales tax clearance. We obtain a sales tax clearance from the Florida Department of Revenue. This is extremely important for restaurants, okay? Because even if you buy the assets of the business, if the previous restaurant was not reporting and paying their sales tax, the Florida Department of Revenue will not give you a sales tax certificate until you satisfy the outstanding amount. Okay, I guarantee you that. They don't care that you only bought the assets. They will not let you operate unless you satisfy that. That is why we always require a sales tax clearance, because we want to make sure that our buyer is able to buy the business and go with it. Now, we don't do the financial due diligence, but we can recommend CPAs, we can recommend accountants. I work with a fabulous one, he's my husband, and he can help do all that financial portion of it that we don't do. So why is due diligence so important? Because buyers and sellers are free to ask any questions to complete the transaction. In the event that the buyer finds the property that no longer meets their needs because of the inspection, because of anything, then they're able to get their money back, right? This period also protects the seller once due diligence is over if the buyer decides that they no longer want to buy. It says home, but it should say business for whatever reason. The seller is able to claim the money deposit and then that's it. So it protects both sides, the period of due diligence, and it is so important to do it. All right, let's talk now about the closing process. So what do we do during the closing process? Basically, we finalize the purchase price. Let's say that the inventory was not part of the purchase price or there was going to be an adjustment. We do that, right? If the inventory was taken and it's less, then we can adjust the purchase price. If the inventory was taken is more, then we can adjust the purchase price if that was the original agreement. We prepare any government or tax-related forms. We confirm insurance requirements because the landlord, right, for you to be able to transfer the lease, they're gonna probably ask you for insurance. So we help the client obtain that. We prepare any transfer contracts and agreements. We prepare the transfer of the, the location lease. We prepare the closing documents such as the bill of sale, the closing statement, and we finalize the asset purchase agreement because sometimes we do asset purchase agreements where everything is signed at closing because we have a letter of intent. Sometimes we do asset purchase agreements that are signed before and then we just close. It just depends on the deal and the transaction. We then schedule the closing. We receive all the funds to be able to distribute it according to the closing statement. And we prepared, the contract, the asset purchase agreement, we review it. It's always so important to review all documents with your attorney. Then we finalize the deal. So after we finalize the deal, we're ready to close. These two documents that I'm going to mention right now are extremely important if you're representing the buyer. Non-competition and non-solicitation agreement. So non-competition agreement is important because you don't want the seller to sell you the business and then open right next door and then compete with you. They know your clients, they know your vendors, they could just take them from you. So typically a non-compete agreement is a contract between an employee and an employer where the employee agrees not to enter into competition with the employer after the employee terminates or is terminated. However, in a business sale, the buyer should strive to have the seller sign one for the same reason. So the seller agrees not to enter into competition with the buyer for a certain period of time and or within a specific mile radius of the business. So we negotiate, we'd say, okay, the seller's selling the business, they cannot open the same business in Miami-Dade County, Broward County, or within 45-mile radius for a period of 3 years, 5 years. It just depends on what you agree. So important. If you're representing the buyer, they have to sign a non-competition agreement at closing. Non-solicitation agreement. A non-solicitation agreement is a contract in which an employee agrees not to solicit the company's clients or customers for his or her own benefit or for the benefit of a competitor after leaving the company. However, in a business sale, the same applies. It should be signed by the seller in order to ensure that he or she will not solicit their previous clients or customers. We don't want them to solicit clients, customers, or employees. We want the seller to go and buy. We don't want them to come and ruin the business. If you don't have those signed at closing and the seller sells the business, there's really nothing that stops the seller from putting a shop right next door, from soliciting all your clients, from soliciting everybody. There's really nothing if you didn't make them sign this. And it's so sad when I see this and it's litigation and they signed nothing to be protected. And then there's absolutely nothing that I can do. So anyway, my contact information is there. You guys can find me everywhere on social media with my name, Romy Jurado, ROMYJURADO. My phone number is there. And now I'm going to see if I have any questions. Okay. People want a copy of the recording? Absolutely. I will send a copy of the recording to everybody that registered. I don't see any more questions. So I want to thank you all for joining me. I like to make my presentations short and sweet. Oh, somebody's asking me for an E2 visa, can they have a partner? Yes, they can, but the partner should own 49% or less. That's how I like to do my transactions anyway. So that way the main investor, the 51% owner, is the one applying for the visa and is the one that's control of the business. They can have many partners too. They can have 10 partners, 20 partners, as long as the investor, the E2 visa person that's applying, owns at least 51%. Do you write? Okay, let's see more questions. Yay, I love questions. All right. Let's see. When purchasing an internet business, does the same apply? Yes, you can do an internet business for an E2 visa. We want to have a virtual office. We want to have licenses and permits for the virtual office to show immigration that we are an actual business. We also want to have at least 2 US employees for an E2 visa. And we also help with license permits too. I forgot to tell you guys that. We do licensing, permitting, warrants, anywhere all over the state of Florida. Do you write the business contract for the buyer? Absolutely. We write the letter of intent, we write the business contract, the employment agreement, any type of contracts. We do trademarks, copyrights, anything that has to do with business, we do it. So please reach out to us. Do you have a charge for the buyer for closing since the title company isn't involved? Okay, so title companies are not involved in business purchases because there is no property. And I'm able to represent the buyer and still prepare the closing documents for the seller as long as I make them sign a non-representation agreement. And yes, I do charge them some fee, but I don't represent them. Same thing for the buyer. But when buying a business, I usually like to represent the buyers because I like to do the due diligence for them. I like to help them with the transfer of the lease, with all the licensing, all the permits, transferring the employees, all of that. So that once the buyer buys the business, they're good to go. They can start making money. I don't see any more questions, but I want to thank you all for being here with me today. I know the new year is coming. It's going to be a fabulous year. I want to wish you all happy holidays, a wonderful new year. Thank you for everybody that has contacted me in the past, and I look forward to working with all of you in the future. Again, my name is Romy Jurado. I'm an attorney here in Florida. While my office is in Miami, we represent clients all over the state of Florida and all over the United States for immigration and trademark purposes. Thank you so much. Happy holidays. Happy New Year. Wish you all the best.